Hello, everyone, and welcome to today's webinar. My name is Olga Bodie, and I'm a Syngap parent and part of the team at Syngap Research Fund. Our presentation today is 6 steps to connecting the dots, an objective approach for meaningful parent participation in the education of children with disabilities under the Individuals with Disabilities Education Act as a panelist. I have the pleasure to introduce today's speaker, Dr. Richard Peterson. Dr. Peterson is director of the USC Gould Center for Dispute Resolution and adjunct professor of law at the USC Gould School of Law. Previously at USC, he served as a lecturer in law, teaching the ADR law and policy course, and also served briefly as senior director for experimental education prior to his current appointment. Before coming to USC in 2017, Richard was on the faculty of the Pepperdine University School of Law, where he served for 15 years. Including as a member of the faculty of the Strauss Institute for Dispute Resolution. While at Pepperdine, Richard also served as director of the Special Education Advocacy Clinic and as director of externships. Professor Peterson holds a BSL and a JD from Western State University, as well as an MDR and LLM in dispute resolution from Pepperdine. Richard has served as chair of the disability law section and the law and mental disability section of the Association of American Law Schools, as well as a member of the board of directors of a member of nonprofit corporations, including the Regional Center of Orange County, Down Syndrome Association of Orange County, and as a member of the Professional Advisory Board of the Epilepsy Alliance of Orange County. His scholarly publications include articles on the topic of therapeutic jurisprudence and special education. Before beginning his teaching career in 2002, Richard has worked as a consultant to inner city schools, districts, and schools across the nation, teaching dispute resolution and anger management curriculum to K through 12 teachers, administrators, and probation officers as part of gang violence prevention programs. He began practicing law in 1979 and has served as a private mediator and arbitrator for more than 35 years. Richard has an AV rating with Martindale Hebel. And also today, Richard is joined by his longtime colleague, Richard Earhart, who's principal and owner of consulting firm, Richard Earhart Associates. Thank you for joining us today. A recorded version of this webinar will be available on the SRF website under webinars under the webinars title section. By the end of this presentation, you'll have the opportunity to get the answer to your questions. We'd love to hear from you. Please write your question in the Q&A. For those of you just joining us, welcome again. And our speaker is Dr. Richard Peterson, and his presentation today is on the six steps to connecting the dots. It's now my pleasure to turn things over to Dr. Peterson.
Thank you very much. Grateful to be with you and to share some information that I've accumulated and taught over many years. Also grateful to have Richard Earhart with me, who teaches our special education law and dispute resolution class at USC. I will be referring to a number of PowerPoint slides this morning, and you don't have to worry about feverishly taking notes. We will have those posted and made available to you after the presentation. I would just ask if, in using the slides, many professors are very, very guarded about their intellectual property rights. I've developed this information to help parents, so I'm not so much. I just ask that if you do reproduce them, that you produce them in the completely along with the source information. I'm going to pull up my PowerPoint. And I would say, I've been teaching this for over 20 years, and my presentations are the same, whether I'm teaching school districts or parents. And I think that's important. It'll become apparent as I go through this material with you. At the end, you'll have a chance to ask questions. And so here we go. If I can get this to advance. First of all, my understanding is that those of you that are joining us today, have questions about special education advocacy. Most people didn't sign up to parenthood anticipating that they would be in this environment. So they find themselves, we find as parents, find ourselves at a distinct disadvantage. Most of us are not psychologists. We're not speech and language therapists. We're not occupational therapists. And so as we are thrust into this role as advocate for our child, there's a deep sense of responsibility. And so what I'm going to do today is give you an overview and sources to get you on the right path and really solidify some principles and values that are so important. So let me start with the beginning. First of all, to be a good advocate for your child, you need three things: knowledge, skills, and relationships. When I talk about knowledge of the law, and people are intimidated by the law, but you need not be. This is not overly complicated. And I'm going to refer to sections in the law. There's really 5 sections of the IDA that if you were to master those, you would know more, I dare to say, than most educators. Richard, I suspect that you might agree.
Yeah, Richard, I absolutely agree with this. And one of the other things that I would just note with regard to this slide is the importance of relationships. Not only is it a matter of gaining a knowledge of the law and the skills, and I know that you're going to discuss those things a bit more in depth as we go forward, but the importance of relationships and your relationship with the school district. I cannot overestimate or overemphasize, pardon me, the importance of that. And just as you heard Richard Peterson indicate, the presentations that he gives, the same information, whether he is presenting in front of parents or school districts, and this is the same thing with me. I provide the same information in my class at USC in special education law and dispute resolution that I provide to everyone else. So it's basically, we're trying to level the playing field here, and part of that is by developing some positive relationships.
Great. So, in this section about knowledge, skills, and relationships, let me highlight, in addition to what Richard has said, knowledge of the law. And I'm going to give you a source of where to go where you can get a small book that's probably $29 or $30, somewhere around there, that will give you what you need for the law. The student's disability and being associated with this foundation is an important step. I'm impressed with this foundation and with your parent group on how you work together. So knowing your student's disability is very, very important. You're going to encounter educators that do not know the unique needs of your child. Remember, you are the only permanent member of the child's IEP team. You'll be there from the beginning to end, and there will be many educators that will rotate in and out. So knowing about your child's disability, and particularly how that disability or those disabilities impact your child's learning. Also, knowledge of dispute resolution, how to resolve conflict, how to manage conflict. This is a very emotional environment, and you will encounter people that you believe are not acting in your child's best interest. Knowing how to deal with those people with strong emotions is very important. I kind of capture that feeling by the old saying, you need to know how to tell someone to go to hell in such a way that they look forward to the trip. All right, so skills. Again, skills with respect to your student's disability and with respect to dispute resolution. Relationships, as Professor Earhart had said, with individuals. And when I say that, the most important people that you can have a relationship with is your child's teacher. Now, I've written a couple articles on this dynamic, and you can research my academic articles by going to the faculty page at USC. But teachers, I have found, generally want to do the right thing. They're often constrained by administration. And one of the articles I wrote and researched showed that in the first 5 years of a special education teacher's career, we lose 50% of those teachers. Now, I don't know if that's still accurate from when I published my research and writing back almost 10 years ago, but I suspect that it probably is. So you want to have a relationship, and I'm not talking about a relationship where you're going out to dinner and things. I'm talking about having a trusting relationship where you can confide in the teacher, and most importantly, the teacher can confide in you. If your teacher ever gives you information, never throw them under the bus. And I will tell you, having worked with teachers in children's IEPs, it would not be uncommon for me to get a phone call from a teacher saying, look, I really can't say this, but, and so value those relationships. It's been said that the single most important factor in a quality special education or an education of any kind is geography. And I don't mean by state, I don't even mean by county or even school district, although that is very, very important. The very school, sometimes the very classroom that your child in makes a huge difference. So let me give you some of the nuts and bolts. Understanding the very nature of special education law, called the Individuals with Disabilities Education Act, is important. And there's a cycle to this process. It begins with assessments and evaluations, which identify your child's unique needs. For assessments and evaluation, I'm going to come back to that. This is just a roadmap. You identify your child's unique needs. You develop with the IEP team measurable annual goals that will address those unique needs. Then you provide special education, related services, supplemental aids and services, modified curriculum, and so forth to allow your child to meet those goals, to make progress and achieve those goals. You monitor progress, and then you make adjustments when necessary. So that's kind of a roadmap in terms of the overall process. Now, here's the 6 steps to connecting the dots, which is going to form the basis of our discussion today. I developed this to give parents a sense of objective participation. You know, when you don't know what other folks know in terms of professionals, it's easy to default to emotion, to demands, maybe a focus on services rather than on all of the components that go together. In fact, when I've talked to parents on occasion, they will often say, why do we have to deal with all the assessment stuff? I want to know what they're going to do. Let's get to the services. And having a discussion about the services can be a lot more difficult if you don't engage in an objective discussion and analysis of the first step, identifying unique needs. So I'll come back to this. So let's talk about the law. These are the 5 sections that I would like you to know, and I'm going to give you some background with respect to them. This is in 20 U.S. Code, section 1400. Now, the special education law began really in 1975 with a law called the Education for All Handicapped Children's Act. It was the first law that mandated special education or any education be provided to children with disabilities. Prior to those years, many children, most, were not included in education. They were in institutions and very, very neglected. There was a series of federal cases that came down that held that children with disabilities were entitled to a free and appropriate public education. These were prior to 1975. So in 1975, Congress took the bold move of enacting this prior law so that you get some understanding that didn't sit well with the educational community in a couple of respects. And I'm just going to touch on it. There are provisions in the IDA that require school district to provide speech and language therapy, occupational therapy, physical therapy, and educators from the very beginning said that's not education. So there was a lot of litigation that followed that tried on the educational side to restrict the definition of special education. And it didn't work. It's been expanded. The law, I will say, is very good. I am amazed at how good it is. Implementation, on the other hand, has been a challenge. Better in many areas, it's excellent, but in many areas, it's still challenging. So here's the 5 sections: findings and purpose. Congress set out what they were going to do, why they were going to do it. The findings and the purpose, that's really important. It's kind of a mission statement for the law. Section 1401 will give you definitions. Section 1412 is kind of a catch-all, but important because it also includes the concept of least restrictive environment. Section 1414 is perhaps, for many in the process of developing an educational plan, where the nuts and bolts are evaluations and reevaluations and IEPs. And then 1415 is your procedural safeguards as a parent. So let me start here with congressional findings.
Professor Peterson, I have to interrupt you.
Please do.
If I may, please. Can you go back to your previous slide just briefly?
Yes.
Thank you. One of the things that you've heard Professor Peterson speak about knowledge of the law, and a great place to start with this, and an area where I see parents and school district staff alike really make a mistake in IEP meetings. Those of you that have been in an IEP meeting know that at every IEP meeting, you are asked the question, do you have any questions about your procedural safeguards? Have you been provided a copy of your procedural safeguards? And what I typically see parents do in terms of these meetings is they just kind of nod and go, yep, fine. And more than often, they really haven't taken the time to read this document. I just did a presentation for a group of parents in San Diego County, specifically on the procedural safeguards. And the San Diego County Office of Education, the document that they've produced that basically capture the procedural safeguards is about a 7 or 8 page document. If you will take the time to actually read your procedural safeguards, and this is outside of the IEP meeting, believe me, some evening, some morning, just take the time to go through them. That will give you such a much greater understanding of the law without having to go through and read the entire statute. And so I would just encourage you to take some time and do that, because it's an area where I see, over my 30 plus years of experience in special education, I've seen parents give this area short shrift. So thank you.
Thank you. So the congressional, very important to understand those. I wouldn't have them take the time, and that's not what Richard's saying in the IEP to read them to you.
No.
But yes, understanding them. So the congressional findings, this is the mission statement. And let me also say this about the law. When you're dealing with educators, many of them have not had even this depth of training in the law, and their understanding and perception of the law may come from administrators and other people, and it may not be accurate, let me just say. Now, I'm going to make some statements about educators, but let me also make sure and make clear, I love our educators. I approach this with the idea that they're in education because they want to make a difference. Sometimes the system makes it hard, but this is the mission statement. Disability is a natural part of the human experience and in no way diminishes the right of individuals to participate in or contribute to society. Improving educational results, doesn't say efforts, results for children with disabilities is an essential element of our national policy of ensuring equality of opportunity, full participation, independent living, and economic self-sufficiency for individuals with disabilities. And because of our shortened time, I'm going to go through a lot of these very quickly. I don't need to read the law to you. I'll explain the concepts, but one of the research projects and articles that I wrote deals with low expectations. Congress said, as part of their findings, the implementation of this act has been impeded by low expectations and an insufficient focus on applying replicable research on proven methods of teaching and learning for children with disabilities. Now, in 1975, when the law was passed, every few years, they reauthorized the law. And all along, the first time they said, well, 5 years of experience has shown us that implementation of this act has been impeded, and 10 years, and 15 years, and 20 years. So we still have that problem. Here's the 6 major principles of special education law under the IDEA. Zero reject means all children are entitled to special education. No one is so intensely or severely disabled that they are unqualified or undeserving. Identification, assessment, and evaluation. That's the very foundation. And if you don't get that right, it's like building a house on sand. Mm-hmm. Parental involvement is also a major principle. And these 3 at the bottom are foundational because parental involvement was really counterintuitive and contrary to educational policy prior to 1975. In fact, many times now you'll hear teachers say, give me your child and get out of the way. I know what we're doing. We're the professionals.
The thing I would note there also, Professor Peterson, is in California right now, California statutes actually require that the IEP process provides for an opportunity for parents to provide meaningful participation in that IEP meeting. And there's actually some documentation there that needs to take place. And if the California Department of Education sees that parents aren't being given the opportunity for, quote, meaningful participation, there's a problem and can likely lead to a compliance complaint.
Thank you. Just above that, least restrictive environment. And that was contrary to really what public policy and society thought. Least restrictive, and I won't do a lot of talking about that today, but I will talk about it. It's an extremely important concept. Appropriate education. Law says every child with disabilities is entitled to a free, appropriate public education. A lot of debate over what it means to have appropriate education. I think the law is clear, but the interpretation by administrative law judges and other people who make decisions with respect to this don't always track. And I'll talk about that a little bit later as well. Procedural safeguards are your rights as a parent if you disagree, if there is a conflict. Let me pass this up. What I think about in talking to parents in school districts is I want to think about outcomes, not just process. And I thought this statement was important from the President's Commission on the Excellence in Special Education. The IDEA is generally providing basic legal safeguards and access for children. However, the current system often places process above results and bureaucratic compliance above student achievement, excellence, and outcomes. So it's like building a house, having a foundation with all of those things that I mentioned before that are so important. Let's talk about assessments and evaluations. There are two purposes for assessments and evaluations. One is determine eligibility. With some disabilities like Syngap, it's obvious that's not going to be a problem. But another significant and perhaps the most important is to identify educational needs of the student. And when I use the term educational, I'm not talking about only academics. For many children, education begins with the very ability to develop self-help skills like feeding, eating. Those are things that school educational agencies at the state and local level were so unhappy about. So what we have assessments is to identify unique needs. What does the student need to learn to do or do better? And what does the student need to learn to stop doing? What are the conditions that the student needs for learning? Now, let me just kind of put this all together. When I first started in this, there was a lot of resistance from school districts to consider and bring in information from outside their school IEP team. For example, you'll have private occupational therapists, physical therapists, neurologists, neurosurgeons in many cases, so many speech and language therapists, educational psychologists. The point I make to school districts and to parents is there needs to be collaboration amongst all of those sources. I was so gratified at the IEP for my son, David, who lives in Harrisonburg and is a professor in the School of Management there. In meeting with their IEP team, they were absolutely enthusiastic and embraced all of the information they got from private providers. And the bigger the picture, the better in terms of that. Sometimes you'll have a child that will do certain things at school, but being able to generalize skills to other contexts and environments is difficult. So it's important for the IEP team to know what's going on, not only at school, but at home with other therapists and otherwise in the community.
And Professor Peterson, I would add here as well, in terms of the whole issue of present level of performance with regard to a student with disabilities, the parent input there is as valuable as any assessment or evaluation that you might see. In many cases, all of the experts have brought in their information. The questions are still unanswered, and it isn't until the parent brings forward something that is taking place at home that unlocks the key in terms of what is actually taking place with this student, with this child, and that by opening up that lock, it enables the team to move forward and develop a more appropriate IEP for that child. I can't overemphasize the importance of parents' active involvement in this.
Absolutely. You know, there's so many nuances in what children do and won't do. And often children with a profile of Syngap or epilepsy or autism, many of those windows open and close for learning. And a child that has a lot of seizures is not going to always be optimally ready to learn. So if they're in group activities where the whole class is just doing the same thing, that may not meet their unique needs. And so being able to expand the resources, and by expand, I mean, as a parent, and this goes to part to knowledge and skills, I like parents to know what the therapists are doing, so that they can model and work and reinforce what's being done at school and with private therapists at home. Very, very important. But if you don't correctly identify a child's unique needs, everything built on top of that will be problematic. Then once we do that, well, here's another kind of visual for unique needs. The school is required to assess the child in all areas of suspected disability. And every person has a developmental profile. Some will need more, have more unique needs in some areas than others. So as you go around this, what we would do in our clinic is when we would look at the reports and assessments, we would highlight the background of these in red if there was a unique need, or green if there wasn't a unique need. And then we would take each of these domains and then make sure that we tease out from the assessments what the unique needs are. An assessment should specify what those unique needs are and what a child needs. Often you will run into educators. They rarely, at least my experience has been, make specific recommendations as to services in their reports. So you may need to tease that out so that you have a full understanding of what is being recommended. So in developing the IEP, what must the IEP team consider? The strengths of the child. So many times parents say, I went to an IEP, I was so depressed. I heard for 2 or 3 hours everything that was wrong with my child, everything they couldn't do. Should be an emphasis also on the strengths of the child, the concerns of the parents for enhancing the education of their child. Now, in my son's situation, it couldn't have done better. I mean, they worked hard. I'm working with on another matter where it was exactly the opposite. And you'll find that approach anywhere along a continuum where some will go with their agenda and then say, oh, any parent concerns, and they'll take down a few notes or whatever and just move on. So the concerns of the parents is something that's very important. The results of the initial evaluation or most recent evaluation of the child, that should be reviewed. As well as, let me say, any other assessments or evaluations of the child. So if you have private assessments, I recommend using those unless you have a reason not to. If you have some psychiatric records or personal records that you feel are not appropriate. Otherwise, make sure that they're in the record, that you utilize those, and try to encourage the IEP team to consider those. Now, they're obligated by law to consider them. They're not obligated to follow them. And some consideration is better than others. I mean, some consideration is, okay, we looked at it and then it goes into a pile. So that's important. The academic, developmental, and functional needs of the child. I highlight that because in many educational agencies' view, education is what goes on at school. A lot of times tied to academics, even functional academics. But the academic, developmental, and functional needs of the child are important. This highlights it's not just academic, it's these other things as well.
Professor,
by the way, special education is a service, not a place. And I'll talk about that in a minute.
Yeah, Professor Peterson, if I could speak to the issue of strengths, the child's strengths, as you mentioned, and the reason for that, and it can be given short shrift by IEP teams that aren't really doing a comprehensive job. But if the IEP team will actually look at the strengths of the child in the development of the goals and objectives for the child in terms of addressing the deficit areas. All childs have some areas of strength, and if you can utilize those areas of strength to help assist addressing the deficit areas, that's another key to a successful and meaningful IEP for a child. Thank you.
Thank you. Okay, let me cover something that is extremely important. In my work, I found that, and I'm not exaggerating, over 90%, maybe it was 95% at first, of the goals that were written for children were not measurable, were not appropriate. And many educational agencies have goal banks where they will go to this menu and just drop things down instead of them being created. So I'm going to talk about goals, because that, if you don't get the goals right, and if you don't have them measurable, you're going to be fighting with a ghost, trying to figure out what in the heck's going on. Goals must be measurable. So when we're talking about present levels of performance, those should be specifically related to the goals. Many IEPs have a separate section, present levels of performance, and a separate section for goals. And present levels of performance might be, well, Mary comes to school and is happy, loves to play in the playground. My favorites are smells so nice and looks so happy, and all of these things, on and on and on and on. And then when it gets to the goals, there isn't a baseline. You can't measure progress if you don't know where you're starting. So baseline should be included with and specifically related to every goal. For example, if a child's going to learn, and I'm just going to use this as an example because the math is simple. If a child is going to learn 50 sight words, I want to know, how many sight words does a child know now? Because if the goal is to know a total of 50 and they already know 48 in a year, learning 2 is not very good. So you need to have that. It should be stated with clarity. It should not require reference to additional information to comprehend. It should provide for accountability, allow for objective measurement of progress, and include academic achievement and functional performance. So goals should include all of these things. The baseline, the goal should be able to be interpreted in and of itself, stated with clarity, not require reference to additional information. So if you have a goal that says, Mary will improve her social interaction with peers, or Johnny will be happier at school, and over a number of years, I've seen this. Mary will be happier in 70% of the time in 8 out of 8 trials. It seemed like if you put a percentage and number of trials, you could make anything measurable. That's not the case. You should be able, and what I've always said, the simple way to think about this, I should be able to visualize the child doing what is called for in the goal. I should be able to see them doing it. And goals should be realistic. Some of them say, well, it's 70 or 60% because we want to be realistic. Well, I don't want to see a goal that says Johnny will cross the street safely 6 out of 10 times. There are some that require absolute correctness. Behaviors, are one. So these things are all important. Putting this together.
Let me stop you there again, Professor Peterson, if I
Sure.
may. This articulation between the present levels of performance and goals and objectives is huge, and it's something that that I discuss with school districts in trainings that I provide for them. Also, in my course at USC. Present levels of performance are basically based from the assessment information that you've heard Professor Peterson discuss, and also from the input from parents. As you're developing the present levels of performance are negotiable. That's a discussion that is held at the IEP meeting. They are negotiable, and once you reach agreement on the present levels of performance, only then can you go forward to develop meaningful goals and objectives. If the IEP team does not have agreement on the present levels of performance, i.e. what the child knows and understands what he or she can do right now, if that isn't agreed upon, you can't even write a meaningful goal. And so the process here is present levels, goals and objectives, and then placement. And I know that Professor Peterson's going to get there later on in the presentation, but I have to bring out and emphasize the importance of reaching agreement on present levels, not going to goals and objectives until you have that agreement. And once you have that agreement on present levels, you can then develop appropriate goals and objectives. And that's what Professor Peterson is talking about when he speaks to baseline. Your baseline are those present levels. What is it that the child knows and understands what he or she can do right now?
Thank you that's such an important point. Don't just blindly accept what the school says as to what the child can do or not do. Many times the school will say, well, I have one right now where the reports of teachers in a situation where they're trying to remove a child from a regular classroom, the present levels say that the student does not interact or socialize with typical peers and feels uncomfortable. And that's just flat out not true. And when I look at the assessments, I always look for areas of bias. And in this particular situation, it was clear. All the academic teachers appeared to get together and have a party line. That was their party line. They forgot to include the coaches and people who readily said that this child was loved by everybody and socialized and so forth. Quick bit of advice, and this is powerful. If your child can do things the school district's saying that your child cannot do, video. It doesn't have to be fabulous. It doesn't have to be professional. Take your iPhone or your smartphone device and video your child doing that. And show it to them. Now, sometimes it's a problem of a child not generalizing these skills to other environments, but sometimes it's just totally inaccurate. Okay, so annual goals, and I'm going to try to go through the last slides quickly so we have plenty of time for question and answer. Study these slides. Address the unique needs, measurable and measured, report progress, revisit and revise. That's the process. Here in these slides, we'll tell you what goals should have. And that's emphasizing what I said before. It's an observable learner performance. Like I said, I want to be able to, if you can't envision in your mind what your child would be doing to achieve that goal, then it's not appropriately written. Learner performance, that's a verb. Conditions. Under what conditions is this going to be done? If a child's going to be learning to do something, is it in a group setting? Is it in the classroom? Is it a structured, a phrase I like is a structured classroom activity, which will identify that. And the criteria, what does the child have to do to achieve that goal? And just saying with anything, some percentage of mastery over so many trials is not in and of itself appropriate. Here's a tool that I developed for our clinic. It's like a ladder. I want to know present level of performance. If a child's going to do something, what can they do now? Many times it's a new skill. The baseline will be 0. I also like to have benchmarks, in many school districts tend to push back on that, but I don't want to wait to the end of the year to know that the child has not met their goal. We want to make adjustments during the year. So I really push to have short-term benchmarks. Now, some schools, as a matter of policy, won't do that. If they won't do it formally in the IEP, do it informally and check with them. Now, in some cases, you have to choose the battles. In my son's school district, they don't generally do that, but the teacher is more than willing. The team is more than willing to do that. So I want to know if the school district's proposing that there be, speech and language for 20 minutes 3 times a week, and there's a certain goal that that child is supposed to achieve in a year. I don't want to wait for a whole year to find out that that wasn't enough or the right kind of intervention. So check periodically, and then you can measure. Now, in my form, in my clinic, I would use fill in a green background as the child made progress. Many school districts want to set their goals so they're easily achievable. One of the reasons why is because they fear being hit with a legal sledgehammer if the child doesn't meet the goal. I say, like anything else, if you're seeing up to 90, 95%, or don't try to hit them over the head with a legal sledgehammer because they didn't hit it on the button. That's important. Here are some things that the IEP must include. And these things are important to know so that you can look to check to see that your IEP for your child.
Professor Peterson, I know that you're trying to move on so we can answer some questions, but a brief word on related services, please. And you had mentioned it earlier in terms of speech language pathology, occupational therapy, and one of your first slides with regards to the law and some pushback from educational agencies initially in terms of the inclusion of these, what we call related services, occupational therapy, speech language pathology. These services, these related services, are services that may be required to address the unique needs of the child with disability in order for that child to, quote, benefit from his or her special education. So the issue of related services, it's not just some service that is out there that's not tied to everything else. It's articulated to the child's unique needs and to the district's duty to address those unique needs. And in that sense, these related services are services that must be implemented in order for this child to receive benefit from his or her special education. So I just had to throw that in, and I believe it's hugely important to understand.
Yes, and especially for the population of Syngap, where children need some pretty intense occupational, physical, speech and language therapy, behavioral interventions, all of these things. And schools, a lot of time, in concern for their budgets, will kind of have a standard. Okay, the child will get, with this kind of disability, will get this much of that. So related services, you may get pushback. And it's the ones that are listed: occupational therapy, physical therapy, speech and language, are examples. It's not an exhaustive list. And so that's very, very important. Specially designed instruction. Understand this. It's content, methodology, and delivery of service. All three. Whether or not the content is modified or a different curriculum, how it's going to be delivered, and then whether or not it's going to be one-to-one or in group. Be very vigilant in knowing what is being done in terms of these three characteristics. A source that I love is Barbara Bateman. I'm not going to read all of her stuff, but this is a book that I have at the end of the slides about writing measurable goals. She says a common practice on IEPs is to write special education in one box and 10 hours a week, and an adjoining box, speech therapy, and so forth. Arguably, that practice does not fulfill the intent of the requirement for the statement. Regardless of its legal sufficiency, unfortunately, it's very often interpreted to be sufficient. The practice is not educationally helpful, nor does it communicate well to the parents. So here's my 6 steps in just a understandable format. And the reason I do this is because you don't want to have an emotional struggle with your school. You want to have an objective measurement. So you start from the left. What are the unique needs? The measurable goals. When will this goal be addressed in the child's educational setting? Sometimes schools will say, oh, our program is rich in content and delivery. That goal will be addressed throughout the child's school day. That doesn't cut it. I want to know when. Take your child's schedule during the day. What is the child doing between 8:30 and 9:30 and 10? And plug in when that goal is going to be worked in. What methodology is going to be used? Who's going to provide the service? And you may get pushback on methodology. I don't use it. So again, I use the term legal sledgehammer. I want to know what they're doing so that the parent can reinforce what's being done. So that's very important. You also want to know if it's scientifically proven method. Very important under the IDA. Who's going to provide the service? I had a school district one time say, oh, our preschool has a 1-to-3 ratio of staff to student. Well, I went over to look at it. They had one teacher and they had 15 what I would call In-N-Out burger, what some of you might call McDonald's burger, whatever you want. And I'm not putting down people that work in those environments or the fact that they might be aides. But those were the people working with the child with one teacher looking around, and they said 1-to-3. Well, quite frankly, that was deceptive. They had one teacher for about 35 kids, preschool age kids, and a lot of aides. Now, aides are very important. I have no problem with aides, but we need to know and distinguish what they're doing versus what the teacher's doing versus what the therapist is doing. For example, if you're not careful, speech and language might be stated in the IEP to be provided in the classroom by the special education teacher. So if you're thinking, well, I'm getting this occupational therapy or speech and language therapy, know who's doing it. And then again, importantly, how will the child's progress be evaluated, and how are the parents going to be notified of that? Very important. Data, not teacher observation, not just teacher observation, data. They don't have to take data every day, but you want to know the child's progress by virtue of something objective, not just what someone's opinion is of that. So very important. Also, how often you will know about the child's progress. Now, sometimes schools will say, well, you get it with like every other child with the report card. That doesn't work. So try to work something out where you're have an understanding of this progress more often.
Professor, if I could just make another comment in terms of that, those 6 steps right there, a one word term that I use for this, and I would ask the parents to take this word and make it your own, and it is operationalize. What I tell the IEP teams to do is operationalize for these parents what's going to take place. And I use virtually the same language that you have in that previous slide. Operationalize who, what, when, where, how much.
Yes.
If the staff can tell you that, and it's not difficult, who, what, when, where, how much, you have operationalized what's taking place for that child, and it will give the parents a clear picture of what is actually taking place. Thank you.
Yeah, and don't do it as if you're challenging them.
Oh, no.
Most educational agencies will be happy to do that. Sometimes it comes across like they're being set up, and I explain to them why we're doing that. One last comment here: organize your educational records. When almost all parents, when I deal with them, they've got so many things going on that you don't have time to organize your educational records. I'm going to give you a simple way to do it that I've taken from a colleague, Pete Wright, and that is, do it chronologically. No matter what the record is, go by date, whether it's an assessment, whether or not it's a progress report, whether or not it's IEP meeting notes. Start chronologically and put every record in chronological order with a table of contents. Get tabs. Start your thing from the very beginning. And we have tabs that go to several hundred. You know, I've had some over many years where we have 5 or 6 notebooks. It's going to be much easier to locate documents if you organize your records and do it, because otherwise you'll be very, very frustrated when you're trying to figure this out, especially when you get several years down the line. Here's some sources. Now, again, I'm not selling anything, but I'll tell you sources that I've used for many, many years. The law. There are many books out there that talk about special education law. Pete Wright's special education law book is concise. It includes the statute, the IDA itself, regulations, some cases. The best source I know, I used it in my teaching. I know Professor Earhart does as well. Over here on the left, Writing Measurable IEP Goals and Objectives by Barbara Bateman. Barbara Bateman has been in special education going back when I was in grade school. She is a pioneer, an expert. She comes from an educational background, and she tells it like it is. You should have these 2 books. You should have these 2 books. The one on the left is just a newer version. You can get them used on Amazon, and they're everybody as well. I think I saw some for $3 or $4. Here's an organization, COPA, the Council of Parent Attorney Advocates. This is a parent organization. Very, very important. Let me, and this is the last thing I'm going to say, rightslaw.com, go there. Every kind of source that you can imagine is there. Go there. So with that, sorry, it took more time than I expected. We'll stop there for questions. Yes, Jackie.
Hi, thank you so much for doing this presentation, because we do get a lot of questions in the group regarding educational rights and some problems that parents are having in the Syngap community. And so much of this information is already relevant to some of the questions we've already had in the group. And some of the things that you talked about, I really just want to retouch because they're so important, and I'm really glad you went over them. Of course, one would be relationships and being able to form those. I too find that to be most important, and it's best just to start with the very first friendly staff member you find, and then that kind of builds. The second part is, yes, a lot of times we do get those people in the IEP meetings who do not have your child's best interest, but I find that it's always best to kind of go into it with the assumption first that, like you said, they just have a lack of knowledge. They have a lot that they learn. They learn how to draft an IEP, how to collect data, and all of these different things. So their information is often more broad in special education law than the parents who end up coming in more informed with time as they learn this. So just to go into it with that, and then you can provide that. You also talked about knowing the law. One thing that I find very helpful is to print it out. Highlight the important things that are going to be discussed in that meeting that are going to be relevant for you, and take copies of it and just pass it around, because you may get some comments like, we've never done this before. This is just the way we do it. And they come at you with an assumption that they know it better than you. And what's written in the law often kind of calms that whole argument a lot of times. And I love that you talked about having appropriate trained staff. That's really big. It's something that I myself have had to advocate for my daughter over the years. And that this includes, especially for Syngap students who, behaviors and severe behaviors oftentimes become a real issue for our kids, that includes that they have a right to have staff that are trained in proven science-based de-escalation methods, and that's something that you can request and talk with the school about, because your children have a right to safety. So let me just go over just a couple of the things that I know specifically are going on with some parents that have reached out to me in the Syngap community. If you could just touch a little bit extra on that. One is that, what can you talk a little bit about the rare occurrence where an IEP plus a 504 might be needed, such as, really intense medical support type things that might not be included in the IEP. Additionally, that ABA is considered a related service if there are these behavior issues that could be just in the same kind of category as OTPT and speech, which schools are much more familiar with, but parents do get a lot of kickback on ABA. So how do they approach that when a school is pushing back on that?
Well, first of all, let me just take that because my short-term memory isn't very good. On the ABA, that's an incredibly important service. And that is a related service. And the IDEA says that special education, is something that is provided in the home, in the community, at schools. And so it's a service, not a place. And the fact that this child may not have problems at school in a certain area, and that's what I hear sometimes as well, that service isn't necessary because we don't see it at school. I had a child with autism that was fine, constrained in a self-contained classroom, but every time the mother or father took the child out into a mall, for example, started screaming to get into an elevator or to do this or that, go to a park, and have meltdowns. Well, we don't see that at school. That's not an appropriate reason not to provide a related service. Now, let me add to this as well. Schools are somewhat limited in what they can do. You gotta pick your battles, because schools sometimes, even if they wanted to, couldn't do what is needed. You need to kind of look at that. To the extent you can, use insurance and those other resources to get outside help to supplement what's going on in school. If you've got great health insurance, a lot of these you can get privately, which to supplement, not take the place of, but to supplement what's going on at school. Make sure that there's that there's that exchange. So let me talk about rights versus reality. The cards are stacked against parents. I've had parents that are fighting over something. I went to speak at a conference one time, and a parent had spent $250,000, was up to the U.S. Circuit Court of Appeal. I never want to have a parent go through that. And I've litigated all the way up to the Circuit Court of Appeal, short of the Supreme Court. I litigate when it's necessary, but it's very expensive, and there is no such thing as educational malpractice. No such thing. Now, there is compensatory education if the school district's not providing something to fill in that gap, to provide what the child would have otherwise received. So use wisdom and pick your battles. The best thing to do is to try to establish a relationship. I've spoken at conferences where, advocates or attorneys pound their fist. Don't you let them, do this or that. And I think to myself, well, that's great advice. It's like the person that's going to face the big bully at school. Don't let that bully push you around. You go, and then the kid comes home knocked out. Choose your battles carefully. Be careful about expenses that you might spend. Again, litigating sometimes is necessary. Know your procedural safeguards. That service that you referenced is important, and your child is entitled to it. That's all I can say. Related services is not a fixed definition of things that fall within that category. If your child needs something to make progress in meeting their goals, to receive an educational benefit, that's why your goals are so important. Make sure that if your child has a need for that intervention, that there's a goal that addresses that. Behaviors is a big one. A lot of schools do not have trained behaviorists. I encountered one situation where I had a child with autism that was 12 years old, came from another country, had never received any services. Child had a behavior problem of clocking the kid in front of him with his shoes. Their behavioral intervention was to ask the mother to wear slippers so it wouldn't hurt so bad. So behavioral intervention is important. And I'll highlight this one procedural safeguard that you do have. If you ever disagree with an evaluation and an assessment by the school in terms of identifying your child's unique needs, you have a right to demand an independent educational evaluation, like another opinion, by a provider of your choice. And if you do, the district has two choices and only two choices. One, they can say yes. The other is not saying no. They can say yes, or they have to file for due process. They have to initiate litigation against you. Some of them will do that. Some of my most litigated cases were those where districts sued parents to bully them. You know, oh, you want an IE? We're going to sue you. So I wish I had more time to go into that, these procedural safeguards. Let me add this too. Audio record every IEP. Don't do it like, I'm going to audio record. I'm going to get you. You know, say, look, this is a lot of information. I have a hard time taking it in all at once. So I hope you don't feel uncomfortable. I want to audio record the IEP so that I can listen to it and really take in everything that is said. And in California, you need to give notice of that before the IEP. I think it's 24-hour notice. Check to see what's required in your state. Audio record and keep that, because that'll be important. And look at your IEP notes. And if many times the people that are taking notes for IEPs are going to frame them consistent with their version of what happened. Read those carefully and add a parent's addendum to clarify. They may say, I'm not going to attach this. If you say, I want this attached to the IEP, it is, okay? Whether they want to or not. So, so do that. Sorry, there's so many things I wish that I could talk to you about. Hopefully we'll be able to do this again. In fact, I've talked to Syngap about doing a series of these. So if that was something that would be helpful, make sure and let that be known.
Professor.
Absolutely. And I just have a couple more things and
Sure.
one last question. I loved it. I loved everything you just said, because that does answer a lot of those questions. When you just talked about knowing the expenses, it is, or being mindful of the expenses. I think that a lot of parents don't know those expenses. And so it is really important to know that source. And for example, does your school have a local match, and how expensive is this going to be for them? Can they afford it? And you can find that information with your state Department of Education and from organizations like Council on Developmental Disabilities. Also with the progress data, I can share later with you guys in the group. I get mine daily. So if that's something that you need, you can get it as much as that. And I have the forms that I can send you guys. And if you disagree on present level, if you could mention or talk a little bit about finding out if the evaluation in and of itself is appropriate. For example, when Jaden was 5, they were giving her an IQ test that was actually for 8 and up. And so that kind of thing often happens. And my question lastly is regarding LRE. I've sat in a lot of IEP meetings over this particular issue. For example, schools often don't know that LRE applies to transportation. You do not have to use a special education busing. They might need to put a 1-to-1 aid or something, but if it would be appropriate, your student has, a right to the least restrictive environment, which might be riding with their residential peers, if that's possible, with a reasonable accommodation. And specials, music and art oftentimes can have that inclusion, or extracurricular activities. They have a right to join clubs and things. But what I find, I get a lot of kickback from schools a lot of times, is them not understanding in a particular instance when 1-to-ones might actually be the least restrictive environment, because a lot of schools just are kind of given this idea that 1-to-ones are always the most restrictive environment. So can you talk to parents about what to do when they're encountering that kind of pushback, when a one-to-one is actually LRE, but they're being told it's not.
Well, I get really frustrated when schools use the LRE argument to not provide services. And quite frankly, I get that all the time. That's just baloney. A one-to-one aid is not most restrictive. That terminology is used to try to turn it back on a parent. But if you have a one-to-one aid that allows a child to interact with typical peers, don't tell me that that's more restrictive than a self-contained classroom. And unfortunately, I get this all the time. The question is, where can the child best meet all of their needs, including social and emotional needs? I've worked a lot with the Down syndrome community. Those kids learn best with typical peers. Sometimes I see kids that their whole life is around typical peers. And then they get to school and they're told to go there. And special education law is civil rights. A child doesn't have to achieve a certain cognitive level to be able to participate with others. Now, I want to say that there is a place for self-contained classrooms. Sometimes kids with very significant cognitive disabilities and so forth need intensive instruction and so forth, but there tends to be a default to that. That's old school, going all the way back to the 70s. And really, I think, unfortunate, children have a right to participate in extracurricular activities. That is a civil right. As a school principal, high school principal say, hey, our football games, are, not during the school day. I don't have to provide bus or any of that to children with our kids with disabilities, do I? Well, do you provide them for typical students? Yes. Well, then, hey, yes, you do. And you shouldn't be saying it like that. I don't have to do this. It's just, to me, it's very upsetting. And I hate to digress, but I went into a school one time and they had plaques up on the wall to recognize kids in general ed that had been working with kids with disabilities. And they were real proud to point that out to me. And I said, well, where are the plaques for the kids with disabilities? What? Where are the plaques of kids with disabilities that these other kids got to associate with? That is just, one of the things that we deal with. We want to change hearts and minds. Okay, hitting them over the head with a legal sledgehammer is very often not helpful. So we need to guide them and help them to discern that. Now, I've found that teachers that are coming through more recent teacher educational programs are more inclined to do that. People my age that have been in this for that long, not so much. Now, I hate to stereotype because that's not always the case. But pick your battles. Pick your battles and be careful not to get sucked in. Attorneys, I don't want to put down attorneys. They're happy to take your money. They'll fight the battles for you. There's no guarantee that you'll win. It's true that a procedural safeguard is that if you prevail, the ID requires the school to pay your attorney's fees. Well, that's a lot of pressure to have to win in order to recover all these costs that you're spending. So I hope I answered that question.
I'd like to jump in here for a second, if I may, Professor Peterson. one of the reoccurring terms that you've discussed since the beginning of this presentation is the term unique needs. And the questions that's just been asked in terms of ABA therapy and related services, and that all goes back to unique needs. And school districts are required to provide an educational program for students with disabilities that addresses a child's unique needs. Sometimes it's difficult to discern exactly what those needs are. And rather than enter into, and I forget the term that you were using, but a term that we used to call legal battleship, rather than go and play legal battleship with the district, that's a losing proposition. I will just tell you that right from the get-go. It's a losing proposition in terms of human cost and fiscal cost. You may prevail if you go into due process, but you probably will not prevail on all issues. Most of the decisions that I see are split in that sense. The district will prevail on some areas, on some issues, parents will prevail on some others. You may recoup your attorney's fees in the areas where you prevailed. The statute of limitations only goes back 2 years. There's a lot of things that are stacked there that make this difficult. At USC, the course that I teach is special education law and dispute resolution. In Professor Peterson's first slide, I believe, or second slide, under skills, successful IEP advocacy, skills, dispute resolution. This is a skill that I would ask you to start looking at rather, and it's in light of your advocacy for your child. What I tell individuals in terms of disputes is try to develop a mediator mindset when you're going into this IEP. Look to the other party's position on this. Basically, in dispute resolution, what we're looking at, you can take a position and you can be wed to your position, and you may or may not prevail. But if you look at interests and common interests that you have in common with the school district, you're more likely to develop an IEP and more likely to come to a resolution of any dispute that you have that will be considered durable. You want a durable resolution to any dispute that you have with the school district. The CEHO, the Special Education Hearing Office in California, which basically provided due process and mediation services prior to the Office of Administrative Hearings, who has that contract with California Department of Education now, in the 90s did conducted a survey, and what they found out was that virtually every case that went to due process where there was a decision rendered, within a year the parties were back in due process, as opposed to parties that entered into a dispute resolution process, such as mediation, early dispute resolution mediation, or the resolution meeting. Those cases tended to not come back at all, because the resolution to those cases was developed by the parties. When you go into litigation, you lose your power. You give your power away to a judge, to a hearing officer. That judge or hearing officer is required to render a decision. If you don't like that decision, your only option is to appeal it. And in some cases, in some circumstances, these cases, as you probably know, move all the way up to the Supreme Court of the United States. Sometimes it takes that.
Yeah, and hopefully we'll have a whole section on these dispute resolution aspects. Let me add this, a very practical approach. When you disagree with the school district over something like ABA, any service, the way to level the playing field is to request an independent education evaluation. Look at the law with respect to that. Now, some school districts might initiate litigation because they think that you're just going to go find someone to say what you want them to say. What I always do with school districts is work with them to find someone that is truly independent, but someone they respect. Because if you get an IEE, an independent education evaluation for ABA, and you get it from someone that will just say anybody needs it. In fact, I had a special ed a director tell me, I don't like that person. They'll say the doorknob needs therapy, so work with them. Now, sometimes school districts, if you ask for an IE, they'll say, oh, we'll give it to you. Here's a list of people to choose from. The trap there is that the people on that list are generally people that they, quite frankly, control or have a lot of influence over. They're people that they use. Not always, not all of them are, but it's not usually not really independent. I always find someone that the school district has respect for, because you get an IE that says my child needs ABA. If they don't have respect for the person, they're required to consider it, not accept it. And that is one of the most potent ways to level the playing field without full out litigation, to get your rights, to get a opinion, a neutral third party opinion. I know we're way out of time. I have plenty of time, but I know this was scheduled for an hour, and I want to be respectful of people's time. I'm willing to answer questions or do whatever's appropriate, but I know we're way past time. So, there are other questions?
Thank
Or
you. I think Robin just might have a question. Robin, I don't know how. I don't know if I can let her in. Sorry. Robin. Does anyone know? Mike's not here anymore.
or
She can type it maybe, Robin, if you want.
She has a question in the Q&A, Lauren. Is that the one you're looking at?
Well, she's got her hand raised.
Oh, okay. So there.
But I don't know. Sorry, guys. But her Q&A, I think she's just having,
okay, I see it.
Okay.
My child, my 6-year-old is in a mobility chair. I want him out of it. I have voiced this, but he still goes into it. These kinds of things, a lot of times school districts are acting to protect against liability. If you have a difference of opinion, and I got this a lot of times where children would be strapped with some kind of harness or whatever. Even found one where if the child wasn't cooperating and walking, they just picked the child up around the belly by the harness and dragged them off. It's very dehumanizing. So my recommendation would be to have one of the doctors or someone do a letter. Don't write it for them, because schools, you don't want to tell the doctor what to say. But if you have some authoritative statement that says, this is not appropriate and this is why, that will be helpful. I've run into that a number of times before. And again, if a child's strapped into a wheelchair or some other kind, when we talk about mobility chair, there are a lot of definitions for that, but that often is not least restrictive environment. It's insulting, dehumanizing. And so the school will just say, well, that's the way it is in our professional opinion. Well, I would say the teacher's opinion on that, or some administrator who isn't a specialist in that, both, again, special education includes social emotional needs too, the right for least restrictive environment. So yeah, that one to me is very upsetting. It could even arise to the violation of a discriminatory action. I'd have to go into it more. But liability is a big thing. Hey, you know, we're not as concerned about the child, we're concerned about getting sued. Well, you do want the child to be safe, but there are many ways that can be done. Sometimes with a one-to-one aid that might be a little more expensive for them than just putting a kid strapped down in some mobility chair.
Professor Peterson, if I was in that particular situation, and I would go back to your previous comment with regard to an independent educational evaluation, and that's where I would start in terms of this, and it goes back to the child's unique needs, and in that sense, that IEE should be able to indicate whether the child actually needs to be in a mobility chair. And here's the other aspect of this: operationalize when the child is going to be in the mobility chair, if that is in fact necessary. Who, when, what, why, you know, who, when, what, why, how much. There may be a time when this is necessary, but it may be completely unnecessary. But assessment, I place tremendous value on assessment in terms of then starting that conversation in what do we actually need to do to address a child's unique needs. I'll also go a step further on in terms of this. There is no price limitation. Cost in terms of this is not a factor, and in California,
Theoretically.
Well, but I'm just saying, you know.
Yes, I know. The law doesn't provide any exception for it costs too much. And there's case law on that as well.
Exactly.
But there's another important question here. What's the best way to provide or prove your child needs a one-to-one aid? Now, I will tell you, you know, school districts, many of them don't like to provide one-to-one aids. If your child's in a fully contained special education classroom, let me give you an example. Schools like to do one size fits all, even in special education classes. Let me give you an example. Went into one where all the children in this special day class, this class for kids with significant disabilities, they were singing the song Wheels on the Bus. Everybody's sung that. I've even sung it as an adult. But as I looked around the class, there were some kids that were singing and they were very engaged. Many of our kids that have epilepsy or seizure disorders or other cognitive disabilities are off looking the other way, totally not engaged, okay? That's not special education. It's also not special education just because the kid's not a behavior problem. The reason they're not a behavior problem is they're sleeping under the desk for 3/4 of the day. That's not special education, okay? So if you're going to face this situation, ultimately, if you've got a school district that's, you know, sticking to their guns, not wanting to provide an aid, an IEE, you get a professional, and it's probably educational psychologist that can look at the child's learning and give objective reasons as to why the child needs an aid. And many times it's to be prompted to engage. Children with seizure disorders, and I've worked with hundreds of families, if not 1,000, they're not engaged. Now, what I often find, and I did this in a video on one matter for an aid, is the child sitting back and a teacher talking, there was nothing, no attention. With that child if I got up close, and let's say this was this pen was colorful, and I got up and I said, Serena, what color is this? I would get her attention. But if I was back where a teacher was standing, I wouldn't. That's not education. Just to exist in a classroom is not an educational benefit. But rather than argue, you will never win an argument because you will get the refrain, well, we're the professionals. We know you want what's best for your child. But we make a recommendation based on our professional judgment. We're the professionals. We know best. In other words, back off. This is the way it's going to be. And I had that problem on a school that was charging a student with a very severe form of epilepsy with being late to school all the time. And somehow there'd been this conflict between the school psychologist and the parent. And the school psychologist got her dug in her heels and said, we've have other kids with epilepsy that get to school on time. Why? There's no reason. They actually started an action against the parents. The solution was the neurologist wrote a letter and said, dear whoever, this child has the worst episodes of seizures that I've ever seen. This child's on the maximum dose of medications. My primary concern is saving this child's life. This child has seizures every day. This child will not be able to be to school every day on time. Now, that trumped everything. No more discussion. If you say it as a parent, and again, I'm giving you worst case scenarios. I'm not going to say every teacher or every, this is the way to respond to those problem areas. You need to level the playing field. And if you have private insurance and so forth, I think every parent ought to have private evaluations if they have insurance to do it. That will help you sleep at night. But if you disagree, and if you have insurance, take advantage of it and do it. If for nothing else, just to check and make sure that you're in sync. Otherwise, independent education evaluation, I have a whole presentation on that. I could spend a lot of time about how to do it correctly so you don't end up in litigation. Thank you.
Perfect. Thank you guys so much for doing this today. We would love to hear more from you.
Thank you.
Certainly a
Nancy
pleasure.
may have. Yeah. Okay, we'll do it again. I'm gonna let it hang up if Olga wants to finish.
Thanks,
Say
Lauren.
anything else?
Professor Peterson and Professor, thank you very much. You've both been very helpful, very informative. Yes, there's a whole lot of topics, and I definitely think ABA is going to be key for us, for the Syngap community. So
Absolutely.
thinking about that one, because I'm fighting that battle myself right now.
There's no question that children are entitled to it. You may also have a state department in California. We have regional centers.
Yes.
There's often a conflict between schools say, well, the regional center should provide that. It should be provided.
Awesome. Well, I'm in Texas.
Unequivocally.
But we have people from all over, and this has been so very, very helpful. We appreciate you both very much. Thank you.
Thank you.